Supreme Court Justice Antonin Scalia found himself in a bit of controversy stemming from a duck hunting trip he went on with Dick Cheney just 3 weeks after the court agreed to hear a case directly involving the vice president. Angrily denying his objectivity is in any way compromised by his friendship with the vice president, Scalia writes, "If it is reasonable to think that a Supreme Court justice can be bought so cheap, the nation is in deeper trouble than I had imagined." In a related story, the nation is in deeper trouble than Antonin Scalia had imagined.
The Supreme Court has become a target for late-night humor in America.
If everyone on the Supreme Court had to recuse themselves every time there was a conflict of interest, we'd never get to see John Roberts' NASCAR robe.
But Supreme Court decisions are no joke. The cases it hears affect every aspect of our lives, from the air we breathe to the safety of our workplaces, to our personal freedoms. The court is the one arena where powerful interests and everyday Americans stand equal before the law. With so much at stake, Supreme Court justices must put the Constitution and the law ahead of personal interests and political agendas. But what happens if their actions jeopardize their impartiality or the legitimacy of their decisions? Federal judges in the district courts and appeals courts must comply with rules known as the Judicial Code of Conduct.
The Judicial Code of Conduct is a body of rules, really ethical rules, about how judges should behave.
Some of the most important canons really relate to ensuring that judges conduct themselves in a way that ensures that they can maintain their independence and that they can maintain their impartiality.
They may not use the prestige of their office to help others through fundraising activities, for example. They must not help private organizations solicit members, raise money.
But there's one big problem. The code applies to every court except the Supreme Court.
When you tell people that the code of conduct applies to everyone but Supreme Court justices, they think it's a joke. I mean, that's how preposterous it is, that they're not bound by it. The notion that they're too awesome to be bound by the rules is just not selling anywhere.
In the past few years, Justices Clarence Thomas and Antonin Scalia have attended political strategy sessions aimed at attracting wealthy donors and influencing elections. These meetings were organized by billionaire conservative activists Charles and David Koch. The Koch brothers have a huge industrial empire, and their fortunes can be directly affected by Supreme Court decisions on many issues.
When the billionaire Koch brothers, Charles Koch and David Koch, sent out invitations last fall for a political retreat in Palm Springs, Charles Koch made note in that letter of the past appearances at that retreat by Supreme Court Justices Clarence Thomas and Antonin Scalia.
Neither Thomas nor Scalia disclosed on their federal disclosure forms that they took a trip that was paid for or that was coincided with a Koch brothers meeting. We found out about it because the Koch brothers, when they were encouraging attendance at this year's meeting of conservative activists, said, "In the past, our meetings have been attended by Justice Scalia and Justice Thomas."
For years, the Kochs have been promoting their own business interests by investing in right-wing groups. That includes $25 million to make you think global warming is a myth. The Kochs have also poured millions into Americans for Prosperity, a group that helped organize many of the first Tea Party rallies.
The goal of the Palm Springs getaway is to, quote, develop strategies to counter the most severe threats facing our free society and to review strategies for combating the multitude of public policies that threaten to destroy America as we know it. The Kochs go on to brag in their invitation about the cavalcade of conservative all-stars they have hosted in retreats past. Their list includes Governors Haley Barbour and Bobby Jindal, Senators Jim DeMint and Tom Coburn, Representatives Mike Pence, Tom Price, and Paul Ryan, and Justices Antonin Scalia and Clarence Thomas of the United States Supreme Court.
This is politics. Bare-knuckled, big money, Republican-Democrat politics. It would be wrong for a justice or a judge to go to one of these events.
This is dubious conduct in private spaces, and both of those things are in doubt to me in terms of judicial conduct, but both of them together is particularly toxic.
Attending this sort of overtly political event would be a violation of the code for any other federal judge.
When we get into a realm where justices attend events or demonstrate support for organizations whose bent is clearly, political in ways that are identifiable, they begin to suggest to the public that maybe you don't have a shot to convince me.
But the Kochs aren't the only ones getting cozy with Supreme Court justices. Take Harlan Crow. He's a Texas billionaire with interests in real estate, hotels, and industrial development. He also funds political groups that push a pro-corporate agenda.
Supreme Court Justice Clarence Thomas is coming under increased scrutiny after the New York Times revealed new details about his close ties to Dallas real estate magnate Harlan Crow, a prominent Republican millionaire. A company controlled by Crow is bankrolling Thomas's pet project, a nonprofit museum in Thomas's hometown of Pinpoint, Georgia. In addition, Crow provided $500,000 to allow Thomas's wife to start a Tea Party group, and he once gave Thomas a $19,000 Bible that belonged to Frederick Douglass.
Reporters discovered that Mr. Crow has given Clarence Thomas trips on his private jet, a cruise on a luxury yacht, even a $500,000 contribution to the Tea Party organization, Liberty Central, headed by Thomas's wife, Virginia. On his financial disclosure forms, Justice Thomas failed for several years to report his wife's income. Virginia Thomas worked for the Heritage Foundation, which weighs in on many major political issues of the day. But for over a decade on his yearly financial disclosure forms, Justice Thomas checked the box none for spousal income. When the news broke, Justice Thomas quickly corrected the forms, claiming he had misunderstood the reporting requirements.
When the information isn't given and then the response is simply, I forgot to fill out the form for a bunch of years, it made it appear as though it was inconsequential to him.
The Judicial Code also prohibits judges from lending their names and prestige to any fundraising activities. But Justice Samuel Alito has served as a keynote speaker at fundraisers for political causes, like the Conservative Intercollegiate Studies Institute. He's also attended and spoken at fundraisers for the American Spectator magazine. When reporters asked whether attending the American Spectator dinner was appropriate, he said it was not important.
And I think that's intriguing, that the idea that he could be participating in a political activity that's a pretty nakedly political activity, and that people would be interested in that, shocked him.
If I'm a judge and I go to their annual fundraising dinner, it would suggest that, I think to the average person, that I'm supporting that cause. I'm lending my name and presence to that cause. And it seems to me that's something a judge and or justice should stay away from.
While the Judicial Code prohibits judges from fundraising and engaging in political activity, it does not prevent them from being in the public eye.
It's a good thing for judges to speak even to ideological organizations. So when Justice Scalia goes to a Federalist Society, or another justice goes and speaks at a progressive organization, I think it's good, depending on what they say.
We don't want them isolated from society. They ought to participate. The line drawn is around participation in avowedly political events or fundraising for specific causes.
But it's not just what justices do off the bench that threatens to undermine public faith in the judiciary. So does failing to step aside from a case when it appears a judge may have a personal or financial stake in the outcome. This fact came into stark relief in a case that thrust Supreme Court ethics into the headlines.
Early on in the Bush administration, Cheney headed what was called sort of an energy policy task force. And the allegation was that he met with a lot of lobbyists for the oil and gas industry to draw up an energy plan.
The Sierra Club wanted to know who were the people who were part of this advisory group. We weren't invited to the meeting, so who was there? And the vice president argued that he did not have to release that information, that it was in fact covered by executive privilege.
The Sierra Club sued, and Vice President Cheney lost in the lower courts. He appealed to the Supreme Court. Just after the court decided to hear the case, LA Times reporter David Savage heard that Vice President Cheney went duck hunting in Louisiana with Justice Scalia.
I sent a note to Justice Scalia and said, "Is this really true?" I said, "You actually went duck hunting with Dick Cheney the week after the Supreme Court agreed to hear this case?" And I said, "Doesn't this raise some sort of, ethical or conflict of interest question?" So he sent me back a sort of a one-page letter, said, "Yes, I went down there. It was a lousy week of duck hunting. But he said, I don't think it violates any code because the code says something like, a judge should not participate in any case where his impartiality might reasonably be questioned." And he said, "No one would question my impartiality in this matter."
But did Justice Scalia step aside? No.
Justice Scalia was a full participant in today's argument, aggressively questioning both sides. He'd been asked to take himself off the case after hunting ducks with the vice president in January.
The job of the justice is to put themselves in the place of the average, reasonable person knowing all the facts. And I think in that case, without question, the average reasonable person knowing all the facts thought that Justice Scalia's impartiality could reasonably be questioned.
Unlike other federal judges, each Supreme Court justice gets the final word on whether they must step aside from a case. Neither the court nor Congress has established a mechanism for review.
The way we do it today, every justice is the final judge of his or her right to sit. If the public begins to believe that it's not about the law, or that the justices are really politicians in robes, or what they do is politics in another form, their credibility will suffer.
From my own experience as a civil rights lawyer, I never had a case in which my clients, no matter what I told them, didn't believe they really had a shot. And every time we erode the power of that moment by giving people the belief that you don't have a shot, it's already been decided. You see, this justice believes this, and we know this because they regularly attend this event, or they showed up at that event, or this is who they, went on vacation with. Every time we do that, we undermine the power of our own democracy. We undermine the legitimacy of our judicial system.
I think the reason that the standard is so much higher for the judiciary is because the amount of power we give them is so much more extraordinary.
No wonder there's growing pressure for reform.
When I talk about this bill back in my district, people are alarmed that there is one code of conduct for the federal judiciary that exempts 9 justices on the Supreme Court. I want to know whether progressive judges, moderate judges, or conservative judges are out there openly coordinating with political groups. That is good for democracy.
Recently, 140 law professors wrote to Congress asking for hearings and new legislation to strengthen the ethical rules protecting the impartiality of the Supreme Court.
That's something that just seems to me obvious that we ought to adopt. I've never understood why it hasn't been implemented. Code of conduct that's right for other judges to preserve the credibility of those courts, why you would not apply the same code of conduct to the Supreme Court.
We want them to be able to operate in ways that are free from the constraints of elections and the polls. And in order to do that, we say there's this one thing you give us back, which is you behave in a way that always and forever signals to us that you're putting us first, that you're putting the law first.
All of us have a right to a Supreme Court that upholds our constitutional rights and freedoms. We also have a right to a court that adheres to the highest ethical standards. Reforms are available. Apply the Federal Code of Conduct to the Supreme Court without question. And make sure recusal decisions are transparent and reviewable. With so much at stake, we urge you to explore this vital issue with us at afj.org. I'm Edward James Olmos. Thank you for watching.